My name is Bree Van Til, just in case you haven't known that by now. I am the Director of Education here at Alt Legal and your Master of Ceremonies for Alt Legal Connect. As you can see on this slide here, we do have a code of conduct. We aren't playing about it. Please do not be a jerk, please. And if somebody's being a jerk to you, please let us know. You are welcome to use the chat in whichever platform you're in, whether you're in Big Marker or Umbrella. Please use the chat to talk to your fellow attendees. If you have any questions or comments for Brandon, please use @presenter or @Brandon, and we'll make sure that he gets those. This session has been brought to you by Smith.ai. Right, now, I'd like to introduce our speaker, Brandon, who's the managing partner of Leavitt Eldredge Law Firm, where he specializes in clarifying complex concepts of business, law, finance, and science for diverse audiences. It would be difficult to find a type of client or industry that he has not helped. Brandon is a published biochemist and former federal law clerk, and he is listed in the top 5% of Texas attorneys under the age of 40. He's also an Eagle Scout, fluent in Spanish, and a father of 6. If you feed him a pizza, you can be his friend. So here's to more pizza and more friendship with Brandon here. Thank you so very much.
Thank you, Bree. Well, I appreciate all of you who are here. I know that we are coming into the afternoon slump and that I am co-headlining with another presenter who actually is giving you CLE credit. So I would suspect that none of you who are in my session today would be the type of people that would fall under this code of conduct. Moving into the presentation, just to dive in there. So the title of this presentation is Bootstrapping Your Business. And I like the word bootstrapping. It's commonly used amongst my clients, which are going to be primarily venture capitalists and entrepreneurs and even the small mom and pop shops out there. But the reason why I like the word bootstrapping as it applies to any kind of business is because what it actually means is to get oneself or something into or out of a situation using existing resources. You know, if you've got some kind of an investment from Daddy Warbucks, you're not bootstrapping. You've got investors. You've got to play to those investors. You've got to meet their expectations, their requirements. But if you can bootstrap, that basically means you can do it from the resources you have. You don't have to go out looking for more. And so if you can grow out of your existing resources, it's usually an ideal situation if you want to have more control and flexibility in your own life and the way that you do things. So bootstrapping is used very commonly in the entrepreneurial world. I like to use it with regards to my own practice and hope to convince all of you to do the same with yours. The fact is, as lawyers, we don't have this great variety of resources. You know, you got all kinds of entrepreneurs, you know, manufacturers and service providers that have all kinds of different things they can provide to a client. But at the end of the day, all we really provide is our time. We trade that time for money. That's the resource, okay? And the problem is trading time for money is actually a terrible way to use to gain resources to bootstrap your business. And the reason is because, first and foremost, you only have so much time. It's not scalable, right? If I'm manufacturing some kind of a widget and I'm selling it on Amazon, I mean, I could sell 1,000 of those in my sleep and who cares, right? I'm making money. I mean, you look at Amazon, Google, all the companies that make the most money out there, they have found a way to scale up what they offer independently of the time that they put into it. And that's really difficult for attorneys, for lots of reasons, not the least of which being the ABA rule saying that you can't be compensated unfairly for what you do. And so it's very easy for us to tie our time to it. Oh, well, that's 3 hours of my time. That's 1 hour of my time. I bill $250 an hour. I bill $350 an hour. But you know what? There's only 24 hours and you're probably sleeping for 6 to 9 of them, statistically speaking. You might be sleeping for less, but the fact is there's only so much available to you, right? The other one is the trade deficit, right? We've heard a lot about trade deficits this year, you know, and that's just the idea of What are you getting in exchange for what you give? And everybody talks about how well lawyers are compensated. They talk about how well we're paid and our hourly rates are so high, and they compare us to doctors and dentists and accountants. But I'm going to show you, just looking at the numbers, how you get a lot less money for your time than you think you do. There have to be, and I'll show you that there are much, much better ways to obtain income for your business than to trade time for it. And the third one is that it's just depressing when you're tied to the billable hours. I mean, I've never heard a single person in all of my career, no law professor, no peer, nobody who says, oh yeah, I live and breathe for the billable hours. I just love it. I get up every day and I bill all day long and I feel so satisfied and happy and my clients love me. I've just never known anybody to have that experience. The fact is that when your value is associated with the time that you put into something, it's actually very devaluing, and we have a tendency to be very depressed as a result of this kind of self-evaluation. So let's just dive first into the concept of there not being enough time in the day, right? We've already mentioned there's only 24 hours. But the fact is, and this is from the National Law Review, I don't ever make up my numbers. If you bill 1,800 billable hours per year, that's considered a low-end requirement for some of the big law firms out there. It actually takes about 2,400 regular hours for you to be able to bill that, okay? And if you're in one of the other types of law firms that require 2,200 billable hours, or maybe you're just a real go-getter and that's what you can do in a year, that's about 3,058 regular hours. And if you were to average that out, excluding weekends, it's about 9.56 hours and 12.18 hours per day. Now, high school Brandon never thought to himself, when I grow up, I want to work 12 hours a day. That is not a thought that went through my head. In fact, even in college, I was like, oh yeah, I'm studying all day long so that I don't have to do this all day long in the future, right? And then I get into college and I get into law school and I realize, holy cow, I'm working so hard for the privilege of working this hard for the rest of my life, right? You've got Dolly Parton complaining in the 1980s about working 9 to 5, and that's the dream, right? And maybe I'm making assumptions. I know there's some people out here who have a really good work-life balance, but to work 9 to 5, I mean, holy cow, my wife would be ecstatic, right? It's just not feasible when you're tying your income to the hours in the day. If you want more income, you're working more hours, and Dolly Parton working 9 to 5, I mean, that's just a pipe dream for us. It's a lot. And the fact is 80% of us, statistically, this is from Clio, okay, 80% of us, we want to grow. We want to make more than we're making. We want to have more experiences, better clients, better what have you, better income. And yet 76% of us are saying we're overworked. Well, think about that. You want to grow, but at the same time, you're overworked. So something is broken, right? It's like when you want to lose weight, but all you eat is donuts. Well, sure, you can count your calories, but you're going to be starving all day long unless you find a way to get those calories in a way that actually sustains you. And that's what I'm hoping to show in this presentation, is how we can do that without feeling so overworked, okay? We mentioned the second factor in time being a terrible resource for bootstrapping is that you just traded at a huge deficit. Now, if you went into law school because you're math averse, I apologize. I'm a scientist, so please forgive me some basic equations here. There are 3 concepts when it comes to valuing your time that you should be aware of. One is the utilization rate, the second is the realization rate, and the third is the collection rate, okay? And as a brief descriptor, if you were to divide the billable hours that you work by the total hours that you work, that's your utilization rate. And it turns out that that's, statistically speaking, 31%. That means that I'm only billing for about 31% of the time that I work. And that feeds into the realization rate. You take the number of billable hours that you have invoiced by the actual billable hours that you've worked, And we're not even invoicing for all the hours we work. That's about 81%. Not a bad number. That means 20% of all the billable hours you work don't even get billed. And the collection rate, well, there's all the hours you've invoiced, but what you actually collect from those invoices is a subset of that. You only collect about 86% of what you actually invoice, which is only 81% of what you actually bill, which is only 31% of what you actually work. So you put all that together and you're making 22% on your time. That's the trade deficit. And I'm just going to let that sink in for a second. You get some people, they're going to complain about high taxes, high tariffs, high sales tax, whatever. And there is nothing the government has ever done to you that is worse than the idea that you only get to make 22% on your time. And we all do it. We all do it. All right. Now, the data indicates that you're not likely to increase the realization and the collection efficiency by much more than what you've already got. 81%, 86%, that's not terrible, right? But even if you manage to do it, you've already lost, by the numbers, 69% of the value of your time just by the utilization rate. So the only realistic way that you're going to get more money from your time is to increase the utilization rate. And both numbers in that equation are to work more. And that is not the solution we want. So before I move on to the next point, just another principle to put here is you look at your hourly rates. You say, oh, well, maybe I don't have to work more. Maybe I can maybe I can bill more, right? My hourly rate is 300, and maybe I can convince somebody to pay 400 an hour. Well, I've just increased my income by 25%. Well, it's flawed thinking, and the reason is because no matter how good you are, your hourly rates will track with the consumer price index. Now, what actually is the consumer price index? That is the price that people are willing to pay for a consumable good. There's a consumer price index for automobiles, for homes, for fruit and vegetables at the grocery store, for batteries, any kind of good that as you use it, it depletes. That's the consumer price index. And for your hourly rate to generally track with the consumer price index, it means the world sees your time as a consumable good. And we treat it that way. We feel that way because if we didn't, 68% of us wouldn't feel so underappreciated by our clients, our partners, our coworkers, what have you, right? We are allowing our time to be consumed as a good, like you would a fruit or a vegetable or a pizza, you name it. And that's not healthy. And then you factor in all the utilization rates and collection rates, et cetera, that I was talking about before, and you're only really going to spend about 2.5 hours of your day on billable work anyway. So these numbers just don't add up. So just as a brief summary to the concept, if you allow yourself to be commoditized, you're replaceable. Everybody's going to be competing with you for these prices. They're going to be racing you to the bottom, so to speak. Oh, well, this guy's billing $250 an hour, but that guy over there, he's only billing $225. So I'm going to go to that lawyer. Well, now you've got to go devalue yourself to go compete with that guy, unless you've got some other way to show that extra value. So you have a tendency to rob yourself of that surplus value. And so when I made this presentation, I actually made it with the idea that we'd be in person and I'd be asking questions, right? So these are going to be some rhetorical questions, but just think to yourself in your practice. How many of you have had a client that questions the value of the time you put into that project? And how many of you had a client mention that someone else was cheaper than you? And have you ever undervalued your own services because you thought not doing so would lose you a client? And if your answer is yes to any one of those questions, then you are treating time as a consumable good, and so are your clients. Which brings me to that point that I wanted to talk about most of all before we dive into the solutions. The time for money is depressing. And just think about it. We have more depression among lawyers than almost any other profession. You go to any long-term multi-day CLE and they're always going to talk about it, right? You've got people like Barbara Bush who would understand this really well. And she said, at the end of your life, you will never regret not having passed one more test, not winning one more verdict, or not closing one more deal. You will regret time not spent with a husband, a friend, a child, or a parent. Now, this is the wife to a US president. She's the mother to a US president. She was a literary activist, an author. I mean, by any successful metric that you could choose, she was a rock star. And this is what she had to say about spending our time and where it should be spent. And you'll note it's not on trading time for money, it's trading time for experiences with family. 28% of us suffer with depression. 19% of us suffer with anxiety. 21% of us are problem drinkers. And according to the Journal for Addiction Medicine, giving up vacations, weekends, evenings, family, and friends is likely a contributing factor. So as a mid-lecture recap, before we move into kind of the solutions that I have here, bootstrapping is the goal. You want to take your existing resources and grow with those. But unless you find some kind of a workaround, your only real resource is time, and time is terrible for growth for the reasons that we've mentioned. What you should be trying to do is you should take your time and create value from that time and then trade the value for money. Now that might sound like some kind of, evangelist, hokey dokey solution. It's not as intuitive as I'm hoping to make it look, but we're going to talk about a little bit about it. But the fact is value is what your client wants from you. They don't actually care about your time. You sell them your time and they're happy to take it. But if you can provide them value, that's really what they're looking for. It's what they're really willing to pay for. And they will pay a premium for it if you can find a way to get it to them. The question is, how do we get value from time? Time is our existing resource. We need to convert it to value, and then we need to sell that value, right? Well, the first thing we do is we convert time into expertise. Then we're going to package that expertise into some product that we can sell, and then we sell that product to our existing clients, okay? This is how you leverage that effort. And I love the idea of leveraging for this, right? Because you take, what's the formula for work? You've got force times distance, right? And it's the idea that the longer the distance, the less force you need to actually get the result that you're looking for. If you shorten that distance, you have to work harder to get the same result. That's how a lever works. That's how a pulley works, right? We want to put the time in to create the value, because if we can increase that value, we don't need to put as much time in later to get the results that we want. That's the idea of leveraging our value from time. All right. Give me a second here to check my notes, make sure that I'm not robbing you guys of anything I had thought about previously. And we'll move on. So here are some basic examples of how this is possible, okay? As you put time into an effort, into any kind of endeavor, you're going to get better at it. That is, all the self-help books out there talk about it. You've got, all the economics books talk about it. But the fact is that people get good at what they spend their time doing, and they spend their time doing the things that they're good at. That's why you see people who do sports as kids. They love it all their lives. They watch it on TV. They're all backseat commentators, right? You get people who play chess, do the same thing, and speech and debate and band. They're all music lovers. You spend your time doing what you're good at, and you get good at what you spend your time doing. So there are two ways to kind of increase your value with your time. You can spend your time on a few narrow pursuits and really dive down into the depths of what's possible. And you become a specialist. The depth of your knowledge is very, very high over a smaller breadth of what's out there. Or you can be a generalist. The breadth of knowledge for a generalist is very, very wide, but they don't necessarily dive in as deep, okay? Now, each of these has their own flaws and opportunities, okay? If I were to make this like target practice, okay, a specialist is going to have fewer arrows, but they're going to hit the bullseye all the time. So if you get a higher score for hitting the bullseye, even though you've got fewer arrows, you're going to do a pretty good job of getting a good score. A generalist is not going to hit the bullseye very often or as often as a specialist, but they get more arrows. And I did just some mathematics here just to show you, but you know, if I'm a specialist and I can go 3 deep on my topic, but I only get the one topic, 1 times 3 is 3, right? If I get 3 arrows and I only get 1 point per arrow, I still get 3, but in a different way, right? And this is the idea that what I'm hoping to show here is that if you are a specialist and you don't focus on being a generalist, you're going to earn more for your time, but you're less flexible to shifts in the consumer market. You get pigeonholed, right? You hear people talk about in their careers, oh, I've been pigeonholed, I've been pigeonholed. It means I'm doing this one thing and I'm not doing anything else. And hopefully I like it, because if I get bored with it, I mean, that really stinks, right? The generalist is the opposite problem. They're going to take in far more volume than a specialist ever will. And they can adapt and they can transfer their skills, but they are at the highest risk of becoming commoditized, because they're not going to be able to charge as much for their time as a specialist would. Okay, over time, your generalists will burn out and your specialists, they get left behind. You need some kind of a hybrid model. And a hybrid model would look something like this, okay? Now, if you are a math junkie or you've got a 5th grader who knows, you know, the formula for a square, I acknowledge that 2 times 2 equals 4 is not a triangle so much as it's a square, but I wanted to visualize it this way. So just bear with me on the mathematical logistical fallacy there. But if you can increase your depth of knowledge and your breadth of knowledge, you don't have to be as broad as a generalist, and you don't have to be as expert as a specialist. You can be somewhere in between on both, and you will have an increase in value. The specialist, if you recall, I'll go back to the slide. They get 1 arrow and they can score 3 points with it. A generalist gets 3 arrows, he can score 1 point with it. A hybrid professional, you give them 2 arrows, they can score 2 points each, and they're going to have a higher score than either. 4 points. Okay? It is akin on the right image here. It's akin to drawing paint along the line, along a horizontal line, and letting that paint drip down. And it's as if to say, if you can get an increase in breadth of knowledge, your expertise is going to vary depending on what it is you've actually been asked to do along that line of knowledge. But some will be deep, some won't be as deep, but you're going to get a lot more volume than just drawing the line. If you explore those different areas in time, that expertise will come like paint running down a canvas. Excuse me. Now, I have neglected the questions. Okay, good. You guys were answering my questions. I appreciate it. And yes, James, this is very similar to the T model of business development, but it's got my own little spins on it for an actual legal practice. So let's do a case study of how you can convert your time into expertise. Okay, we've got Leonardo da Vinci, generally recognized as the Renaissance man, meaning he knew a lot about a lot of things. We recognize him for his art. We recognize him for his engineering. We recognize, I mean, just a list of some of this guy's accomplishments. Let's see, I got it written down here somewhere. All right, he mapped the human heart. Before Leonardo da Vinci, we didn't know what the human heart looked like. He discovered the thyroid. We didn't even know what a thyroid was. He conceived of the first helicopter, the refrigerator, tanks, robots, calculators, not to mention the Mona Lisa, not to mention all his statues and paintings. The guy was considered throughout history and time to be an expert, okay, among the best of the best. And yet, was he the best artist? Opinions may vary, but he definitely lost the statue of David in a very public, like, I don't know what you, like a dance off for sculptures, right? Like, he lost that commission to Michelangelo. Michelangelo beat him out. Was he the best engineer? His designs, they never worked. There were cool thought experiments, and they got him some patronages in some pretty warlike city-states, but they never actually worked on average. But we remember him anyway because he combined these things. He combined art and science and engineering to make contributions to humanity that nobody else had, and very few, if any, people have since. He found a way to take his breadth of expertise and combine it with his actual expertise in a way that had a much, much bigger average or area for everybody else. So let's take this into a lawyer's perspective, okay? I know that this is trademarks, and we're learning about trademarks. My background is I joined the law firm that was doing patents, and I said, well, why in the world are we doing patents and not trademarks? That makes no sense to me. And so I was able to convince my partners to let me build this practice, and we built a really thriving practice. And we did things like this. You get a client, they walk in, they ask you for a design patent. You charge them for the time, you put in the work, you've got these beautiful drawings. Well, maybe there just might be something source identifying about that design. There's no rule you can't have a trade dress and a design patent. In fact, there's a lot of arguments out there saying that it's better because you only get so much coverage on a design patent. You get 14, 15 years out of it, and then it's gone, and anybody else can use it. But during that time period, you have exclusivity, which is just perfect for convincing a trademark examiner or a federal district judge that you've acquired distinctiveness in this thing through your substantially exclusive and continuous use. Because guess what? Nobody else was allowed to use it. You had the design patent. All you have to show is that it actually functions as a trade dress, but you can have them both, right? So if you draft one product, you've basically done all the work to draft the other, and all you have to do is convince your client that there's a value in protecting their brand on top of the product shape itself. Just treat it as your brand and protect that too. You can bill for two products for the amount of work that you've done once. Design patents are strong evidence that the design's not de jure functional, because it can only protect the non-functional elements. And yet, well, I walked you through it already. I won't repeat myself. Another example, okay, this one isn't strictly trade dress, but I'm sure that you've had marks and brands that touch in some way, shape, or form on concepts of trade secret. I know that they're kind of countervailing, right? Like you got to have your brand out there before you can really consider it a brand, and yet trade secrets you try to keep them in. But there's a lot of overlapping Venn diagrams on how these interact. One thing our firm has started to do recently is for all of those kind of bad fit in between products, we started doing trade secrets. A trade secret, all you have to do to really enforce it is show that you took steps to protect it, and that you can define it. But you run into problems on something that you're not putting out there, and now you're in a public, a lawsuit or something like that, and it's all public documents. Well, how are you going to define your secret without actually disclosing your secret? How are you going to show that you took steps to protect it without, again, risking that you're disclosing things to the world and ruining the secret itself? Well, Federal Rules of Evidence 902 subpoint 1 allows you to take documents with a government seal that are issued by government authorities as self-authenticating evidence. All you got to do is present it, and it's authenticated itself for trial, right? And yet they don't publish a patent application. So what we started doing is we'll take trade secrets, we'll draft them up as a trade secret, and we'll file them as a provisional application with the USPTO as if it were a patent. And we intentionally allow that provisional application to expire. We don't even file it with all the parts. So we'll get a notice to file missing parts rejection, and we don't even care, because what we got was we time-stamped that application number on a government document that we can get a certified file wrapper for, and take that to a court of law and provide proof of our secret by application number without having to disclose anything else. Get this one document, you file it under seal, and you've proven 3/4 of your case. Now, I know that doesn't specifically apply to That doesn't specifically apply to trademark law. But I'll bet if you're thinking about it, I mean, the experience might come up where you can do something like that. There's value in it, okay? Now, the important distinction here is going to be defining the difference between what is actually your product and what's a service, okay? Your service is what you're currently selling with your time. I am selling my time as a service to you. It's time driven. The cost is inconsistent because it's a matter of how much time am I actually going to put in on this project? Well, that's a 2-hour project. That's a 4-hour project. That's a 6-hour project. And I hope I don't estimate it wrong, or you might hold me to it when I bill you 8 hours for a quote that's 4. It's great because there's no upfront cost, but that's about the only thing good about it, right? A product is more scalable. It doesn't matter how much time I put into it. If I'm charging, let's say, a flat rate fee for my trademarks, as long as I've got somebody helping me out with those trademarks, or I've priced it in a way that I can do them in high volume efficiently and effectively without committing malpractice, that's scalable, right? It's scalable. It doesn't matter if I take 10 minutes on the trademark search or 30 minutes or 40 minutes on the search. The client has a consistent cost that they can rely on, and they will pay a premium for that. And if there's anybody out there wondering, well, what about, the fair market value for my services, ABA rule, what is it, 4.2? I don't remember, right? Thank you, Matt, about those examples. I've got others if we've got time for it, but this is the kind of stuff that we're talking about, right? And but as far as the fair value compensation for these things, I mean, law firms do this all the time, right? You put it into the contract. This flat rate fee is taking me out of the market for your product. I can't take on other clients like this. I have to give up my right to represent certain other types of clients, and it's earned on receipt. And I don't know about every state out there, but in Texas and other states that I've looked at when I've had clients from other areas, I mean, it's the ABA's okay with that. The local ethics decisions all support billing people in this way, as long as your contract says exactly what it needs to say. It's earned on receipt, and I'm giving up other opportunities to take you on, whether or not you're satisfied with this. You can bill as much as you think is fair for the value of your time without actually having to bill for the time. So some examples in trademark law, and I'm sure that intelligent minds can disagree on where exactly all of these belong, okay? But I generally will charge flat rate work for monitoring trademarks, filing trademarks, dealing with notices and demands. I've got tiers of response fees for, if it's a likelihood of confusion rejection versus a disclaimer rejection. I mean, I'm going to bill different rates for that, but they're going to be flat rate fees. Searching and drafting, USPTO correspondence, proof of use, I might throw that into a flat rate fee, or if it's some special situation, I might throw it into an hourly work. And what I'll normally do is I will estimate in my head how much time it's going to take, and I'll charge it to them as a flat rate fee as kind of a loss leader to bring in more of this flat rate work. Well, I'll tell you what, I'll do the searching for $50, but I'll file the application for $800 if you're, if you do the searching for 20, and I'll do it that way, right? Consultations, TTAB correspondence, federal disputes, that's going to be mostly hourly work. I have not yet found a way around that. And so what I'll try to do is I'll try to use the services as a way to feed my clients some of these flat rate projects and get what I'm going to talk about a little bit later, more of a lifetime value out of that client. Okay. So for example, well, I guess not for example, moving on to another point, I apologize. If you're going to have to learn, if you want to take this business model approach, to really cross-sell. And I think a lot of us do this intuitively, but we don't do it intentionally or methodically, right? You got a client, they come in and they say, well, I've got a product and I want to protect it. Great, let's talk about a patent. There's utility patents, there's design patents. Oh, this is more like a design patent. Well, have you thought about the brand? Have you thought about the trademark? What about the trade dress? What are you going to call this thing? Right? I'll take a patent and I'll turn it into 3 trademarks, one for the shape, one for the name, one for the logo. And I'm still trying to convince somebody to hire me for a smell trademark. That's like my bucket list. I have not yet convinced somebody to hire me for a smell trademark. I've done a lot of color trademarks, which is fun. And I actually did a motion trademark once, which was kind of the pinnacle of my career at one point, but I still haven't done the smell trademark. But if you got a product, you probably have a brand. If you've got a brand, you probably have a business. Well, now you're into business formations and LLCs. Well, if you've done an LLC, they probably want an operating agreement. And if they don't, they should. And it's your job to show them that they should, right? Well, an operating agreement, I mean, it's mostly boilerplate anyway. You tell them to give you your note, tell me what absolutely needs to be in this agreement. I'll fill it in with all the legal boilerplate. I'll do it for a flat rate fee. I'll send it back to you for review. And if you want to make edits, we'll do that hourly. It's easy money. They're already your client. You know they have this need. You tell them that they have this need. They're not going to go to some other lawyer for these things. So even though, yes, this is a trademark conversation, how many times, and this is a rhetorical question as well, but how many times have you had a trademark client ask you about business formation? I'd be surprised if it wasn't 40, 50% of my consultations. Well, what if you've got a product here you've got a brand, but they don't want to tell anybody how to make that brand? Fine, let's talk about it. You don't want to tell anybody how to make this product? Fine, we'll do a trade secret. It all cross-sells one to another, okay? You know who really does this well? It's the banks. They get you when you're 16 years old with a free checking account. By the time you're 18, they've offered you a savings account. Well, now you're going to college, and guess what? They're going to charge you for student loans, and you're going to do it because you don't know any better, and they're the client. They're the bank that you've been using. You're going to trust them. And maybe those student loans get sold somewhere else, but guess what? You're going to at least be thinking about them when it's time to buy your mortgage. You've graduated college. You've got a 401k. You're going to think about using them for 401k. By the time you're 30, 35 years old, your bank has probably grabbed you for 6 to 8 different products because they gave you a free checking account when you were 16 and a free savings account when you're 18. Some of the most profitable numbers for the banks is because they're doing this. There's nothing dishonest about it if you're doing it properly and you're giving them good consultation in the meantime. But why can't you do this? Of course you can, right? And you're increasing the value for that initial time you put in by not commoditizing your time, but giving them value offerings that they can pay you flat rate fees for. So here's some enlightening facts. It's going to cost you 5 to 10 times more resources to get a new client than to sell to an existing client. And long-term clients will spend an average of 67% more than a new client. So if we're looking at what an economist would call it, they call it the recurring revenue model, the customer retention model. I think it's just common sense. Your client already trusts you. They're not inclined to go anywhere else. How many times do we get annoyed when they ask us all these random legal questions that have nothing to do with our specialty? And why would you refer those out? Melissa, makes a good point, right? You got awesome business lawyers who refer their clients out. Just take them all. If you can't, if it's a basic question and you don't know the answer because you don't have the breadth of knowledge, I've never had a client who says no when I say, you know what, I think I understand the logistics of that. I want to give you good advice. I won't charge you for my research, but let me look into that and get back to you. I've never had a client be offended by that. And every once in a while, I will have to refer something out because it is just too far over my head, right? Like when we start talking about anything SEC that is not a Reg D exemption, I'm out. I'm not going to touch it, right? But how many of your clients, and maybe some of you guys are far more successful with far larger clients than I am, but I'd say it's 1 in 100 that I have a client that has any kind of an SEC question that is beyond a Reg D exemption. 1 in 100. I've referred out maybe 3 of these clients in the course of, I don't even know how long I've been practicing. I could count on one hand the clients that I've had to give out to a specialist because that was just something I don't know enough about. And I still have it as a goal to learn a little bit more about these non-Reg D exemptions because holy cow, patent lawyer, trademark lawyer, business formation lawyer, if I could start getting into the venture financing world, I'm everything. I'm a one-stop shop. I haven't done it yet, but it's certainly on my radar. Some sobering facts are that more than half of your clients are shopping around, and they're not shopping around because they don't trust you. They're shopping around because you won't talk to them. You don't answer your emails. You won't answer your voicemails. You're terrible at the phone calls, period. You won't even return them. Over half of us don't return our phone calls. I am just as guilty as all of these numbers would suggest. I fall in all of them. And the reason I don't do it isn't because I don't love my client, isn't because they annoy me, because they sometimes do. It's not because I don't want their money. It's because I have a day packed full of hourly deadlines, and I just don't have time for that 10-minute interruption. You get a potential client, calls you in and says, you know, hey, can I steal 40 minutes of your time to decide whether or not I want you to be my lawyer? You know what? Call my office. I'll put you on my calendar. You're far less likely to get that client than the one who says, absolutely, let's talk about it. Maybe I can bring this down to less than 10 minutes, right? We don't do it because we don't have the time. But when you go away from the commoditization of your time and we start focusing far, far more on the products and the value, you're going to find time to do stuff like this. You're going to find time. You're going to find ways to channel your potential clients and leads into the right areas so that you're doing it efficiently. Let's see. Checking my time here. 15 more minutes. I think we're okay. So the fact is, and I'll give you some more numbers actually. So I gave you numbers. 71% of you are terrible at email. 96% won't answer a voicemail. 71 don't do phone calls. 57 won't even respond. When a client comes to you, okay, 82% of the ones that leave you are going to say that timeliness was important to them. Timeliness is time-based. 81%, all they wanted was an answer to a question. They left you because you couldn't pick up the phone and answer the question. 81%. 80%, they just want an understanding of how they're going to proceed. 76%, they want a clear sense of how much their issue is going to cost. And 74%, they want to know what the full process looks like. I would argue that if you were to kind of find a root cause for all of these clients leaving you, the 81% who want answers, the 80% who want an understanding, the 76% who want to know costs, it's all about you just talking to them. And when you're talking to them, they want to know what the whole process looks like. And if you take the time to say, let me tell you what the whole process looks like, you're going to file an application. I'm going to charge you a flat rate fee for it. It's going to cover the filing fee. You don't need to worry about that. That's built into my flat rate price. 3 to 4 months from now, you may or may not get an office action. I don't think you will because I've already done the homework for you, but it could happen. These examiners, you don't know what they had for breakfast. You don't know who they broke up with last night. They are individuals and they're judge, jury, executioner. If you get one of these office actions, I will likely have to charge you to respond to it. If it's small, this will be my rate. If it's big, this will be my rate. But the good news is you're probably going to overcome that. And if you do, you go into a publication period and you talk about how that looks really expensive if it becomes an issue, but it's only going to become an issue 2 to 5% of the time. And guess what? All you have to do at that point is provide proof you're using the trademark. That's another flat rate fee and it's yours. Now, I can't promise you everything that could go wrong, but in an ideal situation, you're looking at a 6 to 8 month turnaround time from the moment you pay me that first fee, and your total costs are probably this much. Now, if I have that conversation with somebody, it takes me 5-10 minutes, maybe another 3 or 4 minutes to answer their questions. They don't even know what to ask, so they're not going to take that much time, right? And they will probably never bother me again because I've mapped it all out. Some of them will, and I've got procedures in place for when I've got a provision in my contract. I call it the Murkowski clause, but it basically says that I'm a professional and I have independence, and if you take too much of my time, I might have to bill you for it, right? But most of the time, they're not gonna bother you. I mean, some will, but they won't. They'll wait 3 to 4 months, like you told them to. They're not gonna call you up every 2 seconds wanting to know the status update. In 3 to 4 months, when you call them up and say, "Guess what? No office action. You're welcome," they're thrilled. They're thrilled. By the way, in the last 3 to 4 months, I've launched my product. Let's talk about getting more trademarks. Let's talk about designing things the way that we want to design. Let's do a freedom to operate analysis to make sure I'm not stepping on anybody's toes. You take care of your clients, they turn into more and more business for you. Yes, Elise, That experience is one I've had many, many, many times. I am not going to sit here and pretend that I am the best trademark lawyer you've ever met. I'm not that guy. I'm good. I'm very proud of the fact that I'm good. I very seldom make mistakes, and I can almost always fix my own mistakes. But people hire me because I'm accessible. You look at my reviews online. Brandon, talk to me. Brandon, talk to me. Brandon, talk to me. And I get 5 stars for it because I picked up the phone and I talked to someone, and I just took it from big ABC law firm and got, $10,000, $15,000 out of that client because I spent 10 minutes talking to them on the phone. I could do that because unlike those big law firms, I'm not billing for my time. I'm billing for my flat rate products that I create based off of my expertise and breadth, that I put the time into those, and then I just scale those up. So you already got the client. You're the one they trust. Just reward that trust by selling them value. The time works itself out. So I've talked a lot about time. I've got about, I don't know, I always go from hour to hour, but I think we started after the hour, so I've got a little bit more time than maybe I had in my head. Lifetime value is how you should be kind of thinking of these metrics, okay? Your client, I wrote it down, the client doesn't buy the entree, they buy the appetizer, the wine, they might even get dessert, right? They might come in for the appetizer, end up with an entree, or vice versa. If you can cross-sell to these clients, you're gonna make a lot more money for your time. You're gonna do that by increasing your expertise, as we mentioned, right? You've gotta be the lawyer who's broadening your horizons. You've gotta be the lawyer who's drawing these dots and making connections, design patents for trademarks, trade dress for design patents, or provisional filings for trade secrets. I mean, you draw these connections, you sell them to your clients, they already trust you, as long as you're not leading them down some path of lies. I mean, that's good advocacy. And it's good advocacy that pays, right? You curate that menu, you help them choose. And if you can maintain that trust, they will keep coming back. They will keep coming back. So let's just do a case study here, okay? Using my earlier example, okay? My net profits after filing fees and vendor costs and what have you is going to be about $12.30 for a design patent. And for you East Coast people, I'm really sorry. I live in Texas. My expenses are low. So I underprice you guys all the time, right? Competing against somebody in Oklahoma, and they might be able to do better than me. But $12.30 for a flat rate as a product. I'm selling it as a flat rate, not for my time. However fast I can do it and do a good job, that's my fee, okay? But when was the last time you ever filed a patent and had no USPTO correspondence? You're absolutely gonna have USPTO correspondence, all right? Every time an office action comes back, I'm probably gonna get about $1,250 for that office action, all right? That's an hourly service. It's estimated, and I might have more than one office action, but a design patent, probably one, if any at all. But the subtotal net for that design patent is gonna be $24.80, okay? That is the lifetime value of a design patent client who has not had anything sold to them except for the thing they came in asking for. Now for a trademark, after filing fees, I'm probably making about $625 as a flat rate product, okay? And my net profits from the USPTO correspondence, let's just say it's $12.50. Maybe it's higher, maybe it's less. It's gonna depend on how hard we have to fight for it. And I've prepared my client for that too. They come up to me with something that's borderline descriptive, I'm gonna say, look, I mean, you're probably gonna get an office action for being merely descriptive, but here's how I think we would deal with that. Or if I think it's borderline generic, like, look, I mean, we're probably gonna get an office action for being descriptive. We'll respond to that, and we could take you to the supplemental register if we need to. We'll walk them all through it. I'll explain it all, right? But they might actually say you're generic. Well, that might be a big fight. Or you might just decide at that point to give up and hire us for a second one. But I'm telling you right now, so that you're not, so I can manage your expectations, right? So let's say $12.50 for the USPTO correspondence, okay? Well, that's gonna be about $18.75, all right? Now, most of my clients, they're not ready with a specimen for proof of use. So I could actually probably throw another $200 or $300 on there after I've provided proof of use at the end of the process, right after the publication, or maybe even before if I'm worried about some competitors out there. But I'm gonna make about $18.75 on a trademark. All right, so look what happens. Let's say that 70% of my design patent clients will eventually hire me for one trademark and 15% will hire me for two. And those are good numbers. You've got a product, you probably have a brand, and your brand is probably not just a name, it's also probably a logo. It's probably, all kinds of things, right? So I take that 1875 that I would expect from a trademark, times that by 0.5 and another 0.15, showing that 50% and 15% will hire me if they've already got the design patent. And really, the value of a design patent to me is not $24.80, it's $36.98. Likely, with a trademark client, 10% of my trademark clients will eventually hire me to draft one design patent. It's not as much, but design patents make a little bit more money. And keep in mind, trademark and design, I've already done the work, right? So it's just free money minus the filing time and the filing costs, right? But I'm going to make a lifetime value of about $21.23 from a trademark, not the $18.75 that I'm quoting and obtaining from the client after fees. So really, if you're doing the math, I increase my value per trademark by 49% when I sell them a design, even if I don't sell you the design patent. If I offer you the design patent and I offer everyone the design patent, overall, my increase in value is 49%. And I got that mixed up. If I offer trademarks to every design patent client, it's 49%. If I offer design patents to every trademark client, it's 13%. Existing resources, extra value, that's bootstrapping. You can bootstrap from your own existing resources by implementing these principles and concepts. I certainly have. I think it said it in my bio, but we were a patent-only law firm when I joined this law firm. I joined about 5 years ago, maybe 4 years ago, okay? And in those 4 or 5 years, small law firm, we were 1 lawyer before I joined, 2 lawyers when I joined, we're up to 4 now. We've got a portfolio of over 2,000 trademarks. And many of those trademarks have contributed to our portfolio of over 3,000 patents. They feed each other. And it's not just that. I've got a whole ecosystem of support services around these people. Patents, trademarks, business formations, contracts, agreements. It all is designed to support that ecosystem for small inventors and entrepreneurs and businesses. And every once in a while, we'll pick up a big client too, and that feeds us for quite a while as well. All right. It makes me more competitive. All right. Compare this increase in value to an attorney that doesn't offer design patents to his trademark clients or trademarks to his design patent clients. All right. If I'm competing against these people, let's say it's a specialist. Okay. If I'm competing against a specialist, my rates are going to be, I can decrease my rates by 49% and still be equally competitive to a specialist with 49% lower rates. Ask yourself, how many clients, no matter how much they want a specialist, would be willing to pay an extra 50% for them? Some yes, some no. And I don't have to decrease my rates. I just can. I have the option to maintain the same profitability as a specialist. I have that option to do it. Same amount of time, 49% more value. They have to race to the bottom and I don't. Well, let's say I'm competing against a generalist, all right? I can throw that amount into advertising and starve them. They'd have to further commoditize to keep up. They'd have to come up with new products, and I wouldn't, because I've already got that extra value built into my advertising rates. It's also an opportunity, I mentioned a few times earlier in the presentation, it's an opportunity for me to consider throwing in some loss leaders. A loss leader is the idea that I'm going to charge undervalue for a certain product that I know you need right now. And when that turns into a want for something later, or even better, a need for something later, I can charge you full price for it. And because you're already my client, you're not likely going to go somewhere else. You're not going to likely shop it around. Okay. So that's the loss leader. I very rarely charge for a trademark search. I used to. I learned that people are far more likely to become my clients and pay me full value of a trademark and possibly all these other things if I don't charge them for a search? No, that's a knockout search, but that's what most of them really need anyway. Oh, just give me a knockout search. Is this something we can trademark? Let's move forward from there. Every once in a while, they're going to be worried about someone. I'll do a whole infringement analysis, but I'll charge them for that too. I've got products priced for that, right? So, I'm speechless with all the opportunities that I could share, that I could talk about, right? But it's really, at the end of the day, this process is not about my time. It's about the products that I can offer as a result of my time that stack up independently from my time, because I have spent that time making value and selling the value rather than the hours themselves. All right. All right. I've got a question here from Karina. One moment. At what point do I propose cross-selling to my client? I will cross-sell every single time my client opens the door for it. That could be at intake, it could be at the end, it could be in the middle. One thing that I've started doing, for example, at intake is I will have a blurb on my contract that says, you're hiring me for a trademark. This is not going to protect the product. Would you like to talk to me about a patent? You're not hiring me to protect your secrets. Would you like to talk to me about a trade secret? This will protect your brand, but this won't protect your business. Would you like to talk to me about business formation? Or maybe during the consultation, somebody says, you know what? I've got this huge product that I'm launching. I'm really sending it out there. I want you to make sure that I'm not infringing anybody. So I'm not hiring for a trademark. I got my own in-house team for that, but I want you to make sure that I'm not infringing anybody's rights. Great. I'll quote you for a search. I'll do an infringement analysis. And by the way, do you have a separate LLC set up for this venture so that your business doesn't get tanked if for some reason you do get sued? That's business formation, right? They open up the door, but if you've got that breadth of knowledge and just a little level of expertise, you can pepper all of your interactions in with that, right? I'll get the office action back and I'll say, hey, we got an office action. For this. They think there's a likelihood of confusion with this company over here. I actually disagree with them. I think we can overcome it. Here's the price to overcome it. And by the way, do you want me to write those guys a cease and desist letter? And almost always they're going to say, well, yeah. I mean, if they got prior use, why not, right? You got a common law. I mean, it's all this stuff, right? I've threatened all kinds of, concurrent use proceedings and what have you, right? It's these conversations, they evolve per client, but I'm not going to limit myself at any point. I'm going to cross-sell at the intake. I'm going to cross-sell at the end. I'm going to cross-sell at the middle, whatever. I'll even cross-sell when I'm collecting on a delinquent client, because we all have those, right? I'll call up a delinquent client. Hey, it looks like you're $1,200 behind on your bills, and I just want to
moments while he comes back. But also, if you have any questions, please do make sure to put those in the chat. All right, wonderful. Thank you.
All right, I know there's about a 40-second delay, so I was listening to Bree talk and then realized that by being silent, you guys are probably going to hear me be silent for 40 seconds. So I really apologize that. What I was saying, I don't know if I lost it, but what I was saying when I cut myself off because of the AirPods is that I'm not going to restrict myself to any point in the conversation. Oh, well, it's the end of the conversation. I'm not going to do that. I will cross-sell at any point that I think I have an opening, even if I'm just collecting, right? They're $1,200 behind. I call them up and they're deadbeats. I know they're deadbeats. They know I know they're deadbeats. And I'm calling them up and I'm saying, look, guys, you're $1,200 behind on this invoice. And I really want to make sure you don't fall through the cracks because I think there might be an opportunity for this up here. And I can't do it for you if you're behind your bills. And they say, oh, well, let me make it work. And then all of a sudden, they're not delinquents anymore. And I just got new business. Right? Happens all the time. All the time. Let's see what else I have here for you guys. I might have ended a little too early. So I guess if I could give you guys a takeaway, all right, don't allow your clients to treat your time as a commodity. They are inclined to do it. They don't even realize that's what they're doing, but every time they tell you, well, I think I found somebody cheaper, or I think, explain to me why this was 8 hours worth of your time. I mean, these are signals they're treating your time as a commodity. Anytime you've ever devalued yourself because you think, you're not going to get the client because unless you decrease what you think you're worth, right? And even then, that's kind of a fool's game anyway, right? Because I don't know what the hourly rates are for everywhere else in America, but in the Dallas-Fort Worth area, the richest lawyers don't get paid more than $200 per hour than the cheapest lawyers. I mean, that is not that big of a difference if you think about it, right? And that's because the hourly rate has been commoditized. Everything's going to kind of move towards an average. So don't play that game. Break away from that cycle, create commodities from that time that have independent value, and you charge them for the value, not the time. If you're a specialist, offer something new. Offer them a patent. I mean, you can't do patent law if you don't have a patent background, but you can team up with a patent lawyer who doesn't know anything about trademark law. There's no reason you can't do that. Or business formations. You don't have to have a special license for that. All right? If you're generalist, dive deep into something. I'll be the first one to admit, I don't really know how the customs board acts. I'd love to know it because, you know what, it might be simpler than trying to sue all these whack-a-mole, foreign firms that are always putting things up on Amazon. It might be simpler just to stop them at the borders. I don't have the expertise for that. I know some of you probably do, right? So just dive deep in and learn something. And this is how you become that hybrid professional. You become the DaVinci of your industry. And you don't have to actually be the DaVinci of your industry. I mean, everybody here's, intelligent and successful, or we wouldn't be in this room, right? But your clients, I mean, you can be the DaVinci of your industry to your client. I can't tell you how many times I've had clients, they think I'm a genius. They they brag about me to their friends. Oh, I've got this crackerjack lawyer over here, and look what he did for me. And people, they get excited about it, right? And I get it. Like you're a service professional. You're never going to really divorce yourself from that hourly service model, but you can use that hourly rate to springboard into this flat rate value-based model. And I think at the end of the day, it makes a difference if you put in that time to do it this way. It's at least my experience that I can point out to from how we've built this practice. Marcella has asked, Gabrielle has asked if I have an intake person, and Bree has asked how many paralegals and associates support us. I don't have any paralegals. I'm not opposed to having a paralegal, but I have found that I can train a secretary to do what I need for cheaper than a paralegal. And I don't trust them as much as I would a paralegal, but I'm small enough, I still have room to make some oversight there. And I've got some attorneys under me that I've trained up to provide oversight to the secretaries as well. So I'm not opposed to having a paralegal at some point, but I primarily have secretaries, which feeds into Gabrielle's question. I have cross-trained my secretaries, okay? I have no one secretary that's responsible for any one thing. I've got some that just division of labor and efficiency. I'm gonna have a secretary who handles most of the billing and the collections. I'm gonna have a secretary who handles most of I call them pre-fires, right? Before they deserve my attention, I can have a secretary handle a lot of that. I've got secretaries that will put out all the notices. Hey, you've got an office action. Here's a little template that Brandon wrote up, and you want to talk to him about it, I'd be happy to schedule you. I've got one that does scheduling. So I've got 4 secretaries that are supporting a total of 4 lawyers, okay? No one secretary belongs to any one lawyer. They're all doing each other's work. And I've got that I've got that cross training there. That's valuable in my opinion because it allows my secretaries to provide some cross-selling as well. I've been very careful to train them. They don't give legal advice, but pointing out that they might want to talk to a lawyer about protecting their brand is not legal advice. It's, hey, would you like to talk to one of our lawyers about protecting your brand? Well, I never thought about that before. Well, let me put you on the calendar. Brandon will take 5 minutes of his time and walk you through it. So I've got a lot of my lead generation comes from my secretaries, the way I've trained them. No reason it couldn't be a paralegal, but I haven't found the need to hire any at this point in the size of my law firm. So that is about all that I had to say today. I imagine we have a little bit more time. If any of you have questions, I'm happy to answer any questions you have. And I know it'll be about a 40-second lag time before I get that first question, so I'll just sit here and try to look patient.
I would love, let's see here. So Jama is asking, do you assist with trademark disputes? If so, do you assist as far as filing a case in court?
Yeah, so years ago, when we didn't do any kind of litigation or disputes at all, we thought to ourselves, do we want to be the law firm that turns down $1 million lawsuit because we don't know how to do this? We haven't had one. But if it ever came across our desk, do we want to be that law firm that turns it down? And we decided, no, we don't. So we started handling all the little disputes. We started with cease and desist letters, started with infringement analysis. That led into, you do the offhand opposition as well. But every once in a while, you don't have a lot of clients that basically say, hey, oh, well, I'm gonna spend, 6 figures so you can go after this guy. That's not very common, but what usually happens is somebody will sue your client, or somebody will escalate the matter to the point where it's in front of a judge or a jury in some way, shape, or form. And we say, look, we've handled your matter. We are fully aware and familiar with the entire process of how we prosecuted this thing. As long as you trust us to stay on top of the actual rules of evidence and rules of civil procedure, I'm just as qualified as any other lawyer to do it. I just don't necessarily have the experience. And so we did the first several lawsuits for way, way cheap, like half our hourly rates, because we were just learning, and the client knew that we were using them to learn, and actually we won. Great, let's increase the rates. So then we do it again. Let's increase the rates some more. And we win again, and we win. So I'm technically, and this isn't as cool as it actually sounds, but I'm actually undefeated in litigation. And oppositions. I have always reached a favorable outcome for my clients, not always by settlement. So I even killed a plaintiff's trademark. I killed a plaintiff's trademark defending my client. And the reason I killed it was because the other side had no clue whatsoever about trademark law. They were a professional litigation firm. They didn't know trademark law. And litigation, it's all out there, right? There's seminars, there's CLEs, you can take these things, you can learn. It is a lot harder, in my opinion, to learn how to be a trademark specialist than to learn to be a litigator, okay? And so what I did was I took my trademark specialty, and I broadened my expertise and learned a little bit about litigation. And then as I started doing the cases, that expertise grew. And now all of a sudden I have this whole area of expertise. When I go toe to toe with somebody in the court of law, I have not yet, and again, it's not as impressive as it sounds because I've only done 5 or 6 of these lawsuits, right? But I have not yet found someone who can keep up with me on the trademark issues. They might whip me around on civil procedure, but I can fumble my way through that and win on the issues because I understand trademark law. And it won't take more than another 5 or 6 of these lawsuits, and I doubt they'll be able to whip me around on civil procedure either. The first case was a little ugly. I had the judge, Southern District of Texas, that he was a judge. I'm not going to give his name, but he has a reputation down there. Well, he's the kind of judge when a jury member didn't show up for trial, he sent the constables out after her, and they basically bagged her and tagged her while she was at her college class and dragged her in crying, right? And this judge stopped me in the middle of a cross-examination. He said, "Mr. Leavitt, how many trials have you done?" And I was like, "Well, Your Honor, this will be my first one." He says, No, not federal trials. I just want to know how many trials you've done. And I was like, "Your Honor, this is my first one, period." And he was a lot nicer to me after that. And I got through it, and we won.
That's amazing. That's wonderful. For those of you wanting to learn more about how to file with an eye towards litigation, we do have a session at the conference for that. That's Caroline Fox. That will be wonderful there as well. Okay, so we are out of time. If you have more questions for Brandon, again, I would recommend that you use Brella's People function and search for him and schedule a one-on-one meeting with him. I've just volunteered you for that. I hope you're okay with it. But thank you so very much for your time, Brandon. We really appreciate it. Up next at 4:20 Eastern Time, so about 4 minutes, we have defining diversity. It's a huge, huge and really important topic now of all times, but just in general, it's really important. So please do join us there. Thank you all for listening, and thank you, Brandon, for that. It was really inspiring, and I think a lot of people are going to leave this thinking differently about their business, about their time, about their money. So thank you so much for that.
My pleasure. Thank you.
All right, thanks.